Someone make it make sense.
Probably a couple.
Hello, everybody. Dude, we have some news out of Idaho. This was not planned at all until these documents came out. Also, website looks completely different than it used to. Look at this. And I love that they've added this new feature where it tells you what's new. This is insane. So what we're going to do is we're going to cover some of these crazy new filings here and get through as many as we can. And then this should redirect you guys automatically into the next live stream, which will be the Karen Reed hearing from today. Shout out to Abby. Shout out to Toes. Happy to see y'all. Welcome, welcome, welcome. In case anyone hasn't been here in a couple days and hasn't heard the news, we now have memberships as well for anyone who is interested. I'll have Nightbot put a link in the chat as well for that. So awesome, awesome. What a day. All right, so y'all. Okay, so we've got a lot here. Like, look at all this. Look at all this. So a lot of these were filed on the 24th, but they were under seal and now they've been released. So basically that is where we are at with this. So we've got tons to go over now. We covered this, was it yesterday, about Judge Hippler, and it looked like, so he had this order, right? Where was it? Hold on. The order on party stipulated agreement here, right? But it was looking like he wasn't going to unseal these because they were still locked. Well, good news is that's not the case, and here we have it. Abby says she wanted to share good news on her weight loss journey. Congratulations on losing 10 pounds to Abby. That's awesome. Okay, so everything related to striking the death penalty, we're going to cover in a separate live stream, okay? So we're going to table those for now, and we might be able to cover those tomorrow. But there's a couple of these that are especially interesting that I want to start with. Let's start with the suspect vehicle. All right. And if you guys saw the thumbnail, it says mystery coupe, and there's a reason for that. So all right, so this is the defense. So these motion in limines, right? So we got motion in limines from the state, motion in limines from the defense. So we're going to make sure that we're clear about which ones are what. Shout out to Franks, happy to see you. And shout out to, okay, formerly tie knots. Awesome. Thank you for letting me know. And I love that that profile picture. That is sick. So welcome, welcome, welcome. And thanks for letting me know that you're formerly tie knots. Okay, so this particular motion in limine, though, is defense. Okay, so comes now Bryan Kohberger. So this is the 112 King Road, not to be confused with 1122. This is 1112 King Road cameras. Okay, so the state has claimed in various filings and reports that an FBI forensic examiner, Anthony Imel, right, identified the make and model of this vehicle as seen driving in the area of 1122 King. Suspect vehicle 1. Okay, so this is, here we go from the camera. So 3:56:30 a.m., assuming the timestamp's correct, but there it is right there. So this is the first picture of the vehicle. Let me zoom in a little bit more here. So this is very interesting to me because what do you guys think about this? I was telling Twiz this earlier, I had a whole presentation from some point that looked at the different body shapes of the different Elantras over the different years that were included in this range from 2011 to 2016. I don't know what I did with that presentation. But I think that most of us, even if you're not a car person, like I'm not like a car person, person. What even is that, right? But I can look at that body style and tell you that, to me, that looks like a coupe. And here's why. The teeny windows. It looks like a two-door coupe. And I'll tell you why that is something that I tend to be able to identify. And it has to do with getting car sick. So can any of you guys relate? Can any of you guys relate that that if you are if you're prone to being car sick or motion sick, right? Cars that are low to the ground and have tiny windows like that are a nightmare. And like, for me, I wouldn't be able to ride in that car unless I was driving it, because I would get really car sick. So I tend to notice when the cars have like the teeny little windows, and when you look at the slant in the back, right? This to me looks like a coupe. Now here's the second picture. Let me scroll over if I can. Okay, now this one's a lot harder to see. But basically, I mean, God, it's like impossible. It's supposed to be over here to the right. I can't even tell. I was easier to see it on my phone for some reason. I can't. Let me zoom out. I can't even tell. Honestly, I can't even see it in the way it is on the computer. Let me zoom out more. I don't know. I can't even find it anymore in this picture. I mean, I guess there's a car there, kind of. I mean, I don't know. That's kind of insane. And that's 420. I mean, I guess that's supposed to be the car leaving. I mean, you can't really see anything there. I mean, like, you guys agree? Like, this picture's a lot better. But what I'll tell you is, to me, this does not look like an Elantra. Okay, you can see the A-frame. It's not a coupe. Okay, interesting. So here's a footnote. The surveillance footage comes from residents at 112 King Road. 1112 King Road. It depicts the corner of King and Queen Roads into the house with the camera. From that footage, lights from the vehicle can be seen on Wellington Road, a north-south roadway next to the neighborhood. Says the footnote. These photos are from the 1112 King Road camera. Special Agent Imel did not make a vehicle identification, was not made from this footage. So that maybe we could have done a little bit better with the proofreading there. Can you guys see what I mean? Special Agent Imel did not make a vehicle identification, was not made from this footage. That sentence is not as good as it could be. I'll edit it for them. Special Agent Imel did not make a vehicle identification from this footage. Okay. Rather, as noted in emails between Mr. Imel and FBI Special Agent Edward Jacobson, it's clear that the identification of the make and model of the vehicle in this video was made via a separate video taken at 1125 King Road, 1125 Ridge Road. So what this is weird. What this is saying is the way that they tried to identify this vehicle seen here is not from these pictures, but from a separate camera, which basically is assuming it's the same vehicle, right? So a separate vehicle taken at 1125 Ridge Road. Got a great one. All right. There's no continuous footage. And we heard this was referenced in the hearing. There's no continuous footage linking the vehicle at 112 King Road footage and that from Ridge Road. So again, there's no continuous footage linking them. And so what they're saying is they identified this vehicle, right, based on footage from a completely separate place, 1125 Ridge. But there's nothing that links them, right? Additional surveillance footage depicts vehicles, but not identifiable vehicles. Jeff H is here. Welcome back, my friend. That one right there has a signature curve to the point. Are you talking about the first picture or the second picture? There. Okay. So Toes says the first picture is definitely Elantra. Interesting. Did you miss the whole thing? We just got started, Deb. Welcome back, though. Yeah, I was running a little bit behind. I just finished teaching literally and jumped right into the live stream. So, yes. So welcome. So the second picture, I mean, it's just not, I mean, I don't know. You can't really fucking see anything in that, in my opinion. So, okay. So, right. So thus labeling the cars from various bits of footage as the same vehicle is speculative. So that's their point, right? They've got bits and pieces of different camera footage, and there's like basically they're saying it's speculative that it's the same vehicle when there's not continuous footage that links them. Mr. Kohberger seeks an order prohibiting the state linking vehicle identification of the make and model of the vehicle in the 1112 King Road video based on identification of the car at 1125 Ridge Road and referring to the vehicles as suspect vehicle 1. The speculative nature of testifying that the vehicle is the same vehicle renders it irrelevant to these proceedings, far more unfairly prejudicial than, wow, they must have really thrown these together quickly. There's a lot of typos. Than probative. This is also a jury question, and testimony calling the two vehicles the same invades the province of the jury. Thus, the court should exclude the testimony linking the two vehicles as the same. That's a bit interesting because who wrote this? It says, I mean, interesting. Because if it's a question for the jury, then, I mean, that's kind of going against the argument to exclude it, right? But, and there's Denise. Awesome, awesome. What do you think about this, Denise, here? Jeff's saying, how come I can't find these documents? You know what? So I will tell you, I had the hardest time. For any of you guys who are just now joining, it all looks different now, okay? So when I was trying to find these documents, I'd heard that some people could see them and some people couldn't. And when I was trying to load the Idaho judicial case of interest, it wasn't showing anything. Now, when I loaded it, they're there, but this whole thing looks completely different. It's organized differently. It used to be in chronological order from earliest to most recent, right? You used to have to scroll way down. Now, look at this. This is at the top of the thing. It looks completely different. Now, the newest are at the top and it says new. So it's just different. So it might just be you need to refresh it or try a different browser. But I had trouble initially and now I can look at all of them. Look at all that. So there you go. So it's just a very different, it's they must, I think maybe they were like working on the website and that's why there was some trouble and then it took a bit maybe. But so yeah, these are all of the new documents. So yeah, and this is in Chrome. So I don't know if that makes a difference, but hopefully that will help you. It's just the whole thing is different. So, but yeah, so Denise, I had a question for you here. Isn't this interesting here about this part here, right? So it's a motion eliminate to exclude it, right? Because it's speculative. But then they end this here saying this is also a jury question and testimony calling the two vehicles the same invades the problems of the jury. I just found that interesting because it's like, well, if you're saying it's a jury question, then that's like means that, you know, that goes against letting it come in, right? So anyway, okay, so let's go on to the next one because there's a bunch of these. How do I get to it? So let me show you, how did I get to it? If I click on, hold on. So I have it bookmarked. So I have it bookmarked as the Idaho judicial cases of interest. I have it bookmarked. So if I click on the bookmark, it takes me to this. It all looks different now. It all looks different now. And so then from here, then you click on the case number. And then when you click on the case number, it should take you to this. That's what happens to me because I just did it step by step. So hopefully that helps. Twiz is here. Awesome. So Denise is weighing in. If they say it's a 2015 Hyundai Elantra, that's telling the juror something that's not certain. Right. No, I agree. I just thought that if you're going to make a motion and eliminate to exclude it, then if you're then saying it's a question for the jury to determine, it's like conceding that it's coming into trial, I guess is what I was saying. And again, some of these, anything regarding the death penalty, we will cover in a separate live stream, maybe possibly tomorrow. Kind of depends on how long they go with Karen Reed tomorrow. So let's do this one next. So this is 17 pages. Okay, hang on. This is IGG. I want to read this though. All right. So this is the motion in limine number 11 to exclude IgG evidence. So this is a defense filing. Again, defense motion in limine. Okay. So a knife sheath. Go figure. Who knew? Who would have thought, right? Oh, I see what you're saying. Okay, Denise is saying that they can allow the jury can decide make and model. Right. It's an interesting point, right? Because if you've got car people on the jury, that's one thing. But there's definitely going to be people on the jury, I would think, that are like, I know nothing about cars, and I would feel uncomfortable making that decision, and I would want an expert, an expert, quote unquote, to tell me what it is, right? I mean, that's how a lot of jurors will think, and that's true with anything, right? Like just like with medicine, autopsy and whatever the fuck else, right? They're going to rely on, expertise. And now, of course, and sometimes you'll have jurors that have that expertise in their own life, and then a bit different. Yeah, so some people are saying that in the first picture, they think it looks like an Elantra Twiz. I still don't know. I still think it looks Coopy to me. Coopy. Okay, so all right, so the knife sheath that was recovered at 1122 King Road, The sheath was tested using standard DNA STR methods by the Idaho State Police Lab. This profile was uploaded to the CODIS DNA database and resulted in no hits to known offenders. And as Brett Payne has told us, they can only upload the one profile at a time. I mean, yeah, okay. MPD, with the assistance of the Idaho State Forensics Lab, look at that space there. It's interesting. Transferred extracted DNA from Q1.1 to Othram Labs located in Texas on November 22nd, 2022. Othram promised to preserve all of its work in this case in the engagement agreement and proceeded to test the Q1.1 DNA using SNP techniques. Othram generated a profile, in scare quotes, using SNP and began building a family tree for Q11. I'm just going to call it that way, looking for the closest relatives of the sample in commercial databases that allow law enforcement searches, GEDmatch Pro and Family Tree DNA. On December 10th, 2022, Othram was asked to cease work on the case by the prosecutors, despite the fact that their genealogy investigation was incomplete. And we have a footnote. Okay. Oh, wow. Othram report. Oh my God. We're going to cover all of these. Don't worry, guys. We're just dipping our toes in since they just released all these at once, like the floodgates, right? Othram reported that they had identified a number of close relations to the knife sheath via searches of Family Tree DNA and GEDmatch Pro, and suggested obtaining DNA samples from 3 individuals to further their investigation, the quote-unquote brothers, right? In an email directing the stop work, lab manager Matthew Gamet directed Othram to, quote, preserve the whole genome profile that you have generated on this case, any remaining DNA extract, any data generated on this case, and any other records Othram has on this case, and anything else laid out in the contract with Idaho until the Moscow PD and Latah County POA communicate that such information does not need to be retained by Othram Labs. And this, they gleaned from that hearing. The transcript was recently released. I'm sure you guys have seen, and we covered that as well. I did not see a sunroof. Is there supposed to be a sunroof? I mean, I don't know. I didn't think there, right. The expert does, right. Exactly, Denise. Yes, for sure. Jeff commenting on the sexy curve of the car. Love it. Oh, which one has the images of the car? Got it. So that is, let me answer that question for Jeff here. That is the motion in limine number 12. Motion in limine number 12. It says make and model of suspect vehicle. That's the one you want there, Jeff. And for anyone else who wants to take a better look at those pictures. So for sure, go at it, guys, especially car people. Yeah, I don't know about the sunroof. I'm not seeing a sunroof, but yes, that's correct. There it is. Yes. Okay, so after Mr. Kohberger was charged, he swiftly requested discovery relating to the IgG testing and family tree building that led to his arrest. Mr. Kohberger laid out the rationale for his request in his third motion to compel in a series of affidavits. The state filed a motion for protective order in advance of Mr. Kohberger's motion to compel. In the motion for a protective order, the state drew a strong distinction between the work done by Othram to generate a SNP profile and the work done to generate a family tree from the S&P data, in effect arguing that the family tree building did not fall under the Idaho rule of discovery for a number of reasons. However, in this motion and during the argument on the motion, the state conceded that the testing done by Othram to generate the S&P data fell under ICR 16b5 and stated, quote, the private laboratory developed the S&P profile from the DNA on the KUR knife sheath. As required by Rule 16b5, the state will produce the report that documents that DNA test. Interesting. Interesting. Okay. The court, after hearing testimony from a number of defense expert witnesses, found that the defense had met the threshold, quote, required to show at least some of the IgG information sought is material to the preparation of the defense, end quote, and issued an order for the production of all the IgG information in the possession, custody, or control of the state for in-camera review. Of course, we've covered all this. On November 30th, 2023, the state provided materials to the court for review, along with a table of all the items. These are the things it included. The court ordered release of the majority of the materials with the exception of the generic contract agreements of the MOU. That was the Memorandum of Understanding between ISP, Moscow PD, Latah County prosecuting office attorneys, and Othram. After review of these materials, Mr. Kohberger requested additional discovery materials in his 15th supplemental discovery request relating to the work done by Othram and the FBI, footnote 4. And there's another motion to eliminate. Again, we will read all of these. He sought materials to encompass essentially all the materials that are normally produced, along with lab reports for scientific testing. The state objected, and Mr. Kohberger filed his 5th motion to compel. I remember this. I'm sure you guys do as well. In a hearing on May 30th, 2024, one of the infamous hearings there, extensive expert testimony was again heard by the court as to the necessity of the materials sought. I was here. Love it. Happy to see you, my friend. Oh my God. By the way, the squeaky video, I can't. And same with Batcat. Batcat pretending to be a squirrel. It's too cute. So the requested items included, among other things, raw data files for S&P testing, standard operating procedures, validation summaries, contamination logs, and bioinformatics programs and protocols. At the end of the testimony, the state, through Mr. Nye, argued the motion to compel. In a striking exchange, Mr. Nye represented to the court. So this is quoting from the May 30th, 2024 hearing. Okay. Yes, these have been defense documents, because there's also state motion in limine as well that we'll get to as well. But yeah, these are so far we've done defense. Yes, we love squeaking. By the way, for anyone who's a member, you know how there's member badges? When you get to the 2-month mark, the member badge is actual squeaky. It's actual squeaky, the real life squeaky as a baby squirrel for the second two month badge. Oh, it's a blizzard. Interesting. Stay safe, please. So they had all that info, but didn't show judge in camera at the in-chambers hearing. Correct. Yes. Right. That's a good point. Well, and that's what we're about to get to here, right? Because this is from May 30th. So this would have been before. Wait, no, that was 20. Okay, yeah, no, yeah, here it is. So this 2023, right. Okay. Okay, in a striking exchange, Mr. Nye represented to the court, and then this is a quote. The court makes the decisions. Sorry, let me just make sure I got it. This is a quote, and the quote is what he represented to the court. Okay. Quote, the court makes the decisions, and so we comply with that order. And we reached out to the FBI and Othram and said, you got to give us what you have. We've referenced a letter from the FBI today. I thought the letter itself did a pretty good job. Oh, the letter, laying out what they have, what they do and don't have, what they have access to and what they don't. We have talked to Othram. We've spoken to Othram since we have gotten Exhibit N and provided these requests. And we are not in the position, for example, request 1 through 6, We are not fighting those. I'm not saying we are not going to turn this over. In my view, they fall pretty clearly under the court's order. The issue is we go to Othram and show even these, and Othram says, we've given you everything. You have everything. Everything we have was given to the court and then provided to the defense. Classic, right? So there's nothing on this list that we are holding back because we think we have some justification. Items 1 through 6 in Exhibit N are the materials described above that pertain to the S&P DNA testing done by Othram Labs. Mr. Nye emphasized that Othram told the prosecution that as to the specific requests outlined in items 1 through 6 of Exhibit N, quote, Othram is just telling us we don't have it, so there's nothing we can do. The court then inquired, so Othram has said, you've asked them, and they said, we've given you everything we have. Mr. Nye, yes. Oh, boy. So Mr. Nye reiterated that the state knew that if the documents listed in Exhibit N 1 through 6 existed, the state had an obligation to turn those over to Mr. Kohberger. Quote, and with the rest of it, we are turning it over if it exists and we have it. That's all, end quote. And here's one thing I will say. You know, we're going to redirect. This will redirect you guys automatically into the Karen Reed hearing from today. And one thing I can say, and it'll be pretty clear as well, right, is that things in life are not black and white, right? Like just to the end here. And I mean, this is true for anything, right? Religion, politics, right? There's a lot of instances, right, in life as humans where people pick sides, right? It's this or it's that, it's one side or the other. And I just wanted to say that nobody's ever always in the right. Nobody's always ever only always in the wrong, you know. And like the example I was going to give, right, is like if you take Karen Reed, I mean, I don't know how many people really trust the Commonwealth in that case, right? I think most people would say they trust the defense, but I think we're going to see that the defense has maybe not handled everything as above board as maybe we would have liked when it comes to the Arkadudes. But we will get to that when we get to that hearing today, from today that we're going to watch tonight after this. But my point being that it's not like good versus evil, all, you know what I mean? Some people, like, it could be that when you've got, for example, the prosecution or the defense, in any case, it could be that one side tends to be more truthful than the other side. But what I'm saying is it's not so black and white. And hopefully that makes sense. What do you disagree with, MCAT? But welcome back also. And I don't know if you're talking to me or somebody in the chat, but yeah, so you know, nobody is, it's just, yeah, I think that in general, and maybe this is just a personal philosophy, but getting away from seeing things as black and white, you know, I think is maybe sometimes a good way to approach things. And especially because we, you know, it's always important to stay open-minded as well. So, oh no, of course, right. My point was that the defense being infallible, like with Karen Reed, right? That the defense is only always doing things above board. You know, it was just interesting, like and just as it pertains to the candor to the court with like the Arkadudes, but we'll talk about that. Question there. Let me see. At 14. Where are you seeing this, Deb? Are you seeing this on? Hold on. I want to answer your question. Is this on the screen? I don't think this is on the screen. Where are you seeing that, Deb? It sounds like it could be a reference to a citation, but I'm not quite sure. No, yeah, I agree. I agree. The Commonwealth is definitely I totally agree. But my point was like, in other words, it's while the Commonwealth, people might see the Commonwealth as all bad, the defense is all good. My point is that I think we've learned that nobody's all good, like always, right? Like that's kind of what I was saying. Like they could have done better with certain candor to the court as it pertains to the ARCA dudes. And, that was kind of what I was saying, right? No, so yeah. And there, yeah, no one is perfect. Yep. So Deb, did you hear my question about this? I want to be able to answer that for you. So, okay, but in the meantime, I'll keep reading here. So Mr. Nye said, yes, we've given everything they have. Okay. Mr. Nye reiterated that the state knew that if the documents listed in Exhibit N 1 through 6 existed, the state had an obligation to turn those material over to Mr. Kohberger, quote, and with the rest of it, we are turning it over if it exists, and if we have it, that's all. In the court's order related to the specific request in Exhibit N, the court relied in toto on the representations of the state, specifically referencing Mr. Nye's statement about items 1 through 6. The state indicated that the material sought in this request does not exist. On January 23rd, 2025, a hearing was held before this court regarding the suppression of the DNA IgG and Mr. Kohberger's Frank's proffer hearing. During that hearing, Matthew Gumet testified that the state's relationship with Othram, the contracting process, and specific information about the IgG work done by Othram prior to its S&P data being passed to the FBI. Mr. Gumet was involved in the original process that led to the IgG contract with Othram, which involved coming up with specifications for the scope of work for the contract. Mr. Gumet specifically testified that, quote, protocols were provided back to us as part of the bid. Mr. Gumet also testified that the contract with Othram, and this is from the transcript here, specifies that they would keep any data or other things associated with that. And so in this case, I don't know if they have other data or other records that they have retained. We have asked them as part of the termination in this case of our work that they would preserve those things or that they would communicate with both the prosecutor's office and with Moscow Police Department if any of that information was to be disposed or whatnot. Mr. Gumet states that the protocols and procedures received from Othram in 2021 during the bidding process he believed would likely exist. In response to the new revelations in Mr. Gumet's testimony that the state had in its possession the protocols of the lab through the contracting process as well as other significant materials, Mr. Kohberger filed his 22nd supplemental discovery request on January 28th, 2025. Okay. Requesting multiple items relating to okay. So this is recent. So January 20th, 2025, what this is saying is based on this testimony. So in other words, up until now, it's like Othram's like, we don't have anything else to give you or whatever, but it's like clear that they should have other things. So the defense filed a supplemental request for discovery just on January 28th of this year, asking for the things that Mr. Gumet referenced, okay? In its response dated February 11th, 2025, the state objected to a number of these items. For the purposes of this motion, the state responds to request numbers 424 and 425 raises the specter of prosecutorial misconduct. Mr. Kohberger specifically requested, quote, all Othram lab protocols, policies, and procedures and validation studies in place in December 2022, as testified about by Matthew Gumet on 1/23/25, as well as bench notes, electronic data files, photographs, and quality records. And there's a footnote. These items are essentially identical to items 1 through 6 from Exhibit N. Okay. And let me see if Deb answered my question. Okay, she didn't. I wonder if you're still listening, but I'm going to try to see if I can figure out what she was asking here. Motion for protective. What does at 14 mean? At 14, I'm not sure what she's asking. I'm trying to figure it out. Deb, let me know. I want to answer your question. Okay, so the state objected to this request in particular as being untimely and stated that, quote, the court did not require the state to produce any of the other bidding documentation, including Othram's bid submission that discussed Othram's accreditation status, other customers, past cases, the name and qualifications of the primary genealogist, the name and qualifications of the chief scientist, and the SOPs, which is the standard operating procedures or analytical methods that were to be used. This was the first time that the defense had been made aware of the contents of the material provided to the court for in-camera review. Had Mr. Kohberger known that the materials contained the information described, certainly he would have sought the specific listed information, because he did not know the materials provided to the court included reference to the standard operating procedures and analytical methods. And because Mr. Nye effectively represented that Othram had no such documentation, Mr. Kohberger did not ask the court to reconsider its order regarding production of the materials after the in-camera hearing review at the hearing on May 30th. Okay. Most troubling is the last statement in the state's February 11th, 2025 objection that while the materials provided to the court for review contained references to the SOPs were inadvertently excluded from the materials. Consequently, the court was misled. Oh boy. Oh boy. So this is like they referenced this just a minute ago about borderline prosecutorial misconduct, right? Consequently, the court was misled about the materials reviewed in camera, resulting in deprivation of clearly discoverable documentation. The state objects to the production of materials that it conceded in 2023 Mr. Kohberger was entitled to. Welcome, DB. And anyone else that I missed, because it's harder when I'm reading documents. It's harder for me to read the documents and also keep up with the chat. So welcome to anyone that I've missed. Love you guys. Just 6 days later, the state provided a disclosure for David Mittelman. Mittelman is the CEO of the Othram Labs. The proposed testimony concerns the testing done by Othram to generate the SNP profile. The proposed testimony covers the testing methods used by Othram, validation and quality standards. All of these topics were covered in Mr. Kohberger's fifth motion to compel. Okay. And DB, are you referencing? I assume you're referencing the file, this particular filing. I mean, there's so many of them, but yeah. So this is what's really great is like we're finally getting information about the IGG, right? Like it's all coming out now, and I'm just so happy about that. And releasing that transcript was a big step in the right direction here, because now, like okay, had this been a month ago that this was filed, we wouldn't be reading this. This would be completely sealed, right? And it was initially, and then it was, unsealed. But because all of this is the shit that was not known a month ago, right? Or whatever, 2 months ago, something like that. So argument. Under the due process clause of the 14th Amendment, criminal prosecutions must comport with prevailing notions of fundamental fairness. We have long interpreted this standard of fairness to require that criminal defendants be afforded a meaningful opportunity to present a complete defense. To safeguard that right, the court has developed what might loosely be called the area of constitutionality guaranteed access to evidence. And they're saying some case law here, obviously. David Mittelman, by the way, was disclosed in the state's rebuttal expert disclosure. Separately, the problem of alleged loss or destruction by the state of allegedly exculpatory evidence raised additional difficulties, such as that of deciding how materially favorable the evidence is. Right. This is a good point, right? Because part of the things one of the things that has to be weighed when you're looking at this issue, I feel like in every single case that I'm covering, this comes up, right? Obviously, how material is it to the defense, right? And part of what they're saying is when you're dealing with evidence that you don't have, you can't even determine that in the first place, right? So again, additional difficulties such as that of deciding how materially favorable the evidence is to the defendant's case and implementing an adequate remedy where justified. Usually the only feasible remedy is dismissal of the prosecution or suppression of evidence that would have been impeached by the lost or destroyed evidence. A lot of overlap here with Karen Reed as well. The Lolliport videos. Mr. Kohberger is now asking for the remedy of exclusion because at this late date, he will be unable to investigate the impact of the evidence itself, as well as the consequence of withholding such evidence, even if the missing discovery is produced at this point. Mr. Kohberger's right to receive and review this evidence is guaranteed by the Constitution. In this case, the question of whether the state has withheld or concealed evidence specifically requested by Mr. Kohberger is evident in the record as laid out above. Knowing that Mr. Kohberger was seeking such evidence, the state in bad faith failed to produce the evidence it conceded. So, and then we're looking at Brady violations. So here's the thing, because there's a lot of these filings, I'm not going to read all of this. We can always come back to it, but there's a lot of other things we want to get through. And I think that a key takeaway here is this, right? That we're dealing with here what looks like discovery issues, right? This whole thing about again, we see this in so many cases. We don't have it. We can't turn it over. Well, you did have it. It did exist. They had it. It's like, again, potential Brady violations, right? Constitutional rights. And it's just this whole thing. They've been fighting for this since the beginning, right? I mean, here, the basic tenet of Brady stands to the state. The suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or punishment. And again, that like I was just saying, the difficulty here is being able to determine if the evidence would have been material. But if you don't have it, you can't make that determination. And that's why they're saying it needs to be, that's why there's a motion in limine to exclude this evidence, right? So, and, again, just to reiterate, whether, regardless of what we're looking at here in this particular document has nothing to do with whether it could be anybody. It could be Bryan Kohberger, it could be anybody. Due process is due process, right? Everyone has these constitutional rights. It doesn't matter whether, you may think someone's guilty or not guilty, or if you have no opinion or whatever. Due process is due process. And so when you see stuff that looks like a constitutional rights issue, that matters, right? It is the state's job to prosecute correctly without violating people's rights. Even if they think they have the right guy, it's never an excuse. You guys hopefully are well aware of that, so I will elaborate further. But it's just not how, it's just not okay. So, but for now, let's jump on because we've got so many other filings here. Let's just let's do the one. Where is hold on, I want to find the timing. Where is that? AT&T. The timing advance. Where is that? Here it is. Here it is. So this is from the state, guys. This is from the state. Ready? All right. So this is, again, so state's motion in limine here. So the AT&T timing advance, we were like, right? When we saw this on the docket, we didn't know, it didn't specify who filed it. We were like, who filed it? And are they asking for it to be excluded or included? What's the dealio? Now we have some answers. So this is from the state, the AT&T timing advance records. They want it to be excluded. This is a big deal to me. Okay. I think this is a big deal. This is interesting. This is really, this is huge to me, in my opinion. And hopefully you guys will see why as we go along here and read this. So the state brings this motion based on the defense counsel's repeated references to the alleged existence of AT&T timing advance records related to the defendant's cell phone. The state has been advised and will offer documentation and or testimony that AT&T records are produced by their Global Legal Demand Center. AT&T Global Legal Demand Center did not begin producing timing advance records until May 2023. Let me read that again. The AT&T, we'll just leave out that's where they get the records from. So we'll just say AT&T. So AT&T did not begin producing timing advance records until May 2023. Okay. All records for defendant's phone were obtained from the GLDC in December of 2022. The state intends to supplement this motion with additional information from the FBI and or AT&T prior to the hearing on this motion on April 9th. Any statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is a mischaracterization of the evidence and should not be allowed. Under Idaho Rules of Evidence 403, any probative value of such evidence is outweighed by the danger of misleading the jury, undue delay, and waste of time. For these reasons, the state requests the court issue an order in limine prohibiting the defense from making any reference to the absence of AT&T. Okay, so okay. So when I read this earlier, hold on. So let me read this again. For these reasons, the state requests the court issue an order in limine prohibiting the defense from making any reference to the absence of AT&T timing advance records for Bryan Kohberger. So this is interesting because, I mean, okay, the motion in limine, right, is for the records here, right? Prohibiting the defense from making any reference. Okay, no, never mind. So I'm just going to be more specific here. So when I read this initially earlier, there were all these documents coming out, right? And it sounded and it seemed like they were wanting to exclude the timing advance records, okay? Which was like, but now that I'm reading it again and going and paying more attention to the wording specifically here, that what they're wanting is to prohibit the defense from making any reference to the absence of AT&T timing advance records. So that's a bit different than what I initially understood it. In other words, it doesn't sound like they're asking for the AT&T timing advance records to just be completely excluded. They just are saying they don't want the defense to reference that the absence of them. And what they're saying is because they didn't have the records until May of 2023. So that's a bit different. Twiz, are you listening still? Because I wonder what your thoughts are. And yeah, that's interesting. So it doesn't, so they're not trying to keep the records from coming in. They just don't want them to reference that they don't want the defense to say something about the absence of them or whatever. It's interesting. And it sounds like, again, it looks like they're going to be supplementing this. Where was it? Yeah, the state intends to supplement this motion. So there's going to be more to come on this. Well, this says that there's timing advance records that were produced, but they didn't have it until May 2023. So it sounds like what they're talking about here isn't really what's contained in the timing advance records. It sounds like it's the fact of the matter that they didn't have them until May 2023. It sounds like, well, it's not even that it sounds like. Literally what it says is that they want to preclude the defense from referencing the absence of the records until May 2023 or whatever, because they didn't have it. So, but again, they're going to supplement that. So next we will take a look at let's see here. I want to do the bushy eyebrows, but that's pretty long. So I don't know if we have time for that one tonight. Again, we're going to go through all of these, but we're going to be redirecting into Karen Reed here shortly. So let's do this one. Okay. Because this is short. So this one is motion in limine number 4, use of the terms psychopath or sociopath. So this is a defense motion in limine. So specifically, right. They didn't start producing them until 2023. Right. Yeah. But do you see what I'm saying? That it's different, that they're trying to exclude them referencing the absence of records versus like excluding the records themselves. So this is what it sounds like. Okay. So specifically, this motion seeks to bar the use of the terms psychopath and sociopath. This motion is made pursuant to ICR 47. Idaho Rules of Evidence 4.3 allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply to terminology that is unfairly prejudicial. The use of the word psychopath or sociopath during the course of the trial is unfairly prejudicial. See attached affidavit of Dr. John Edens, footnote 1. Okay, that's referencing the affidavit. This is improper opinion testimony under Idaho Rules of Evidence 701 through 704. Neither term is a proper diagnosis, true, and is unequivocally unfairly prejudicial. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the words psychopath and sociopath. Okay, so we can probably go through another one here quickly before we redirect. Let's do this one because it's in the same type of vein here. Use of the term murder. All right. Another defense filing here. So prohibiting the use of the words murder, murder, or murdered. I mean, I don't think this is going to happen, but there's what they're saying. Murder weapon and similar forms of the word murder. This motion is not seeking a prohibition on the use of the word murder or its varying forms in the charging document or jury instructions. Okay. So they can use it in the charging document and jury instructions. I think this would be pertaining to things like argument, right? Or opening statements, closing arguments. Or potentially maybe if they have an expert for something like this. So whether the killings at issue are murder as allegedly committed by Bryan Kohberger or by an alternate suspect is someone still unknown is the ultimate issue. Each side will present this very argument to the jury. It is a matter of fact to be found by the jury after the court instructs the jury with applicable instructions. To label Mr. Kohberger as a murderer, the alleged weapon consistent with an empty sheath as a murder weapon, or to assert that any of the 4 decedents was murdered by Bryan Kohberger denies his right to fair trial and the right to be presumed innocent. Now, while I do agree with the premise of this, I don't think it's going to go very far. Idaho Rules of Evidence 4.3 allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply to terminology that is unfairly prejudicial. The use of the word murder during the course of the trial is unfairly prejudicial in that it asserts a factual legal conclusion. Right. It does. There's a legal conclusion there, right? A determination which is left to the jury. The prosecutor, law enforcement, and medical examiner are viewed with authority and respect by most jurors. Yup. When persons with authority speak, lay people tend to believe their statements and conclusions. If the prosecution and or witnesses use these words in its case in chief, it would improperly imply to the jury that it is the prosecutor's or witness's belief or opinion that the defendant is guilty of murder. Well, technically, the prosecutor should think that, right, if they're going to be bringing forth charges. But anyway, this is improper opinion testimony under Idaho Rules of Evidence 701 through 704. It is improper for the prosecution to express a personal belief unless the comment is based solely on inference. And then there's a quote, expert testimony that concerns conclusions or opinions that the average juror is qualified to draw from the facts utilizing the juror's common sense and normal experience is inadmissible. Oh, did it take a year to obtain the timing records in the Murdoch case? Well, it didn't take, okay. So for this one, it didn't take a year. It took months or whatever it looks like, right? But you might be thinking of getting into Paul's phone. I think that might be what you're thinking of. They didn't have, AT&T was not in that case. They had Verizon. Verizon was, all the cell phones in that case were Verizon. So you might be thinking of either getting into Paul's phone because the battery was dead. So it was in that situation where it was like first unlock. And so that was the whole thing. Or you might be thinking of the telemetry from the GMC records for the car, which came in mid-trial. But yeah, they didn't use AT&T there. That was all Verizon. Yep. You're welcome. Okay, so Mr. Kohberger requested an order prohibiting the lawyers and witnesses from using the words murder, murder, murdered, murder weapon, as well as derivative forms of the word murder. So with that, we are right in time to redirect over to Karen Reed. So we've got plenty of these. We will work our way through these. Really, I'm so excited to go through these. Especially anything related to striking the death penalty. The autism is going to be really interesting. This is awesome. So it's a lot to digest, but we're gonna just work our way through it little by little. But for right now, we're gonna redirect automatically, and that's true, by the way. Denise saying the car may not even be white. You can't tell from the infrared camera. Correct. Absolutely. So we are going to redirect into Karen Reed, and there may be a surprise redirect after that as well. We'll have to see how long we go with Karen Reed. There may be a surprise live stream after Karen Reed as well, because it was a short day. They didn't go the full day. It was a short day. So we'll see. But for right now, we will redirect into Karen Reed. So hope to see all of you guys there. And if not, love y'all. But hopefully it'll redirect you guys, and the magic of technology will do its thing. And I'll see you guys here in just a second. And I'll just go ahead and roll that outro.